Welcome back to Sunrise Daily, continuing our focus on the Taraba Election Tribunal judgment. Of course, you see some reactions in the papers as well. But the governor has spoken, but we'll bring that to you soon. We're joined this morning by Moyosore Onigbanjo, who is a senior advocate of Nigeria. Thank you for coming on this morning.
Thank you. Pleasure to be back.
Yeah, we're having different interpretations of this judgment. We had that of Chief Michael Zakoma yesterday, giving his perspectives on it. Let's start from getting yours, because many also look to it and say, citing straight away the Electoral Act, under the grounds for you to challenge the election, the first part, they are saying that the intention of that part is not to declare somebody as the winner, but then to just give a rerun. Is that your understanding of the matter?
I have to start by saying I'm a bit hesitant to join the bandwagon to crucify the tribunal, having not read the reason for the rationale for their conclusion. But it also must be said that one has to read it to know why they did not give effect to the provisions of Section 142, which says clearly that if the reason for your nullifying an election is because the candidate who won is not qualified to have contested the election, then you are not to declare the person with the second highest number of votes as the winner, but you order fresh elections. But we haven't read why they arrived at their conclusion, and I would just like to see their reasoning. But, I mean, it is plain that if you are to apply Section 140, subsection 2, then the proper order to make in the circumstances will be to order fresh elections.
And just yesterday we had also a lawyer here who pointed it out that Section 142 had been expunged. I think there was a ruling at the Federal High Court that that part of the Constitution of the Act, if the Electoral Act, should be taken out of the Constitution, out of the Act. But how it still remained there is another thing. Perhaps maybe that was one of the reasons that the tribunal didn't look towards that particular section, 142.
Yes, that's why I said it is very important to really read that judgment and to see the reasoning behind it. Perhaps there might be, like you said, an order of court that has nullified the provisions of Section 140, subsection 2. So at this stage, really, most of these comments are in the realm of guesswork. So it's only the certified true copy of the tribunal, when it is made available to the public, that will now let us know why Section 140, subsection 2 was not applied in this case.
But then, going through a lot of those various perspectives also coming through here, many speak about the testimony of INEC in this case. Well, some lawyers also think that, well, if initially INEC didn't see anything wrong with it until that stage where they went to the tribunal, is there any legal implication in terms of if the PDP were to challenge, could they say INEC couldn't turn back on their words and then come back saying something different, having given them the certificate in the first place?
You see, INEC, their role is to be an impartial arbiter. Their role is to conduct the elections, and I believe one of the provisions of the Electoral Act, in fact, prevents INEC from rejecting any candidate forwarded or nominated by a political party.
Even if they didn't meet?
Yes, even if, because I'm currently handling a case in which that exactly is the situation. So even where INEC knows that a candidate should not run for office, the Electoral Act restricts them because they cannot reject any candidate. So it is now left either to the co-aspirant of that candidate in the same political party to challenge his nomination, or the opposing political parties. So INEC in this instance, their hands are tied by the law. There's nothing they can do. Once a party sends the name to them, they cannot reject it. And again, that accords with common sense, because so that INEC does not become a judge, and INEC should not really have the powers to say Chamberlain can or cannot contest for office. That is a function reserved for the courts.
But then the people are then saying, look, if they don't have that, but you still have that part in the laws which says they may go and maybe observe or supervise.
Yeah.
So what happens to that particular? Should we then take it out if you don't have any powers to do or not?
No, that provision also has its usefulness, because when INEC goes to the primaries, it records what transpires. And in most electoral petition matters, INEC's report of what happened at the tribunal is the only independent report that you're going to get. So in most cases, that report has come in quite handy and useful in a number of instances. So I would not canvass that those powers should be removed, because you still need somebody who goes there and observes independently. They're not partisan, what is happening at the primaries.
Well, the governor did speak. Well, he says I think the main thing he says there is that, which his lawyers would have briefed him, the tribunal left the main prayer and gave something else. I thought they said, look, that can be described as sort of void of discovery.
No. I do not agree with that. If you contest an election and the results go in favor of your opponent, there are various grounds upon which you can challenge his election. One is that he did not score the highest number of votes cast in the election. Two is that he's not qualified to even contest for that office. So if you succeed on any of those grounds, well, according to section 140 subsection 2, if you succeed on the grounds that is not qualified to run for office, fresh elections will be ordered. If you succeed on the ground that he did not secure the highest number of votes cast at the election, then the second person, the person who the court now says has the highest number of votes, will be declared as the elected candidate. So there is no issue there of leaving the main issue. I don't think that holds any water.